Do you know the 5 big traps that defense lawyers use in depositions and injury cases? Well, today I'm going to discuss that. I'm Bob Byrne. I'm a trial attorney who's board certified in handling truck accident cases. I've taken and defended hundreds and hundreds of depositions, and I've seen what can trip up plaintiffs in their personal injury cases. And to be fair to my friends on the defense side of the aisle, a lot of these aren't traps that they necessarily set. They're kind of pitfalls that plaintiffs can walk into. I do have to start with a disclaimer. I'm an attorney and I'm providing some legal information, but this is not legal advice. Every single case is different, and so it's vitally important that if you have a case that you speak with an attorney to find out how all of this stuff may apply to your case. So let's jump right in. The first deposition trap that arises is when plaintiffs have to give estimates of time, speed, and distance. So to explain, most injury cases really go down to a very short moment in time in terms of what happened in a matter of seconds. A good defense attorney is going to dig into that moment of time to see either if the plaintiff, the injured party, did something to cause the accident in some way, or if they had an opportunity to avoid the accident but they failed to take it. So when an injured party is discussing that moment in time, it's very important that they be accurate. And so the problem is a lot of times we talk in figures of speech. So when we're kind of telling a story, someone will say, well, how fast was that guy going? Oh man, that guy was flying. He must have been going 100 miles an hour. Or you think when you're talking to someone, how long were you stopped at the traffic light? Oh man, I was there forever. It felt like an hour. Those are statements that we kind of mention in passing without really thinking about it. And they're kind of little embellishments that make the story funny or something like that. It's important to stop and to think about the actual estimate that you're going to give in terms of perhaps a range, but not just speak in terms of figures of speech. A second trap that arises often deals with the subject of guilt. When something really tragic happens in our lives, we will start playing these mind games with ourselves and we'll say, if only I had done this, if only this had happened instead. And we kind of find that narrow moment in time that I talked about before and say, if only I had taken a different route that day. If only I had left 5 minutes later. And we start to condemn ourselves in a way to say, it was so easy to avoid what happened if only I had done those things. And so some defense attorneys are trained to kind of pick at that, and they will say, could you have done anything different that day to avoid this? But it's incredibly important for you to understand that that is a really, really, really unfair question. And the reason why is because when we're playing these games in our head, it's based on what we know now. It's based on information that was not available to us at the time you were making decisions. At that moment in time that you were acting, you have to look at the information that was available to you at that time. That is a trap that is set. It's an unfair one. And you have to look at things that were based on the information that was available to you at that time, at that place, in that moment. A third trap that arises in plaintiff's depositions deals with medical history. So one of the big issues in just about every personal injury case is whether the injury that occurred was a new one or whether the plaintiff had some sort of pre-existing issue that the defense will try to blame their current condition on. The defense is going to hire a doctor, and the doctor is going to come in and they're going to say, oh, no, this person had this condition, it was a powder keg, and this was just waiting to erupt, and it just happened to erupt at this time period, and it has nothing to do with this crash. And in a way, it's kind of blaming you because it's saying you had this condition, and it just happened to flare up at the same time that you suffered what you know is the injury from this crash. So let's use an example. And let's say that you were in a truck crash and you suffered a bad neck injury as a result. Now, you can expect that you're going to be asked in your deposition, have you ever had neck problems in the past? And in your mind, you're thinking, I've never had, this is new, what I'm dealing with. I've never had issues where I had to turn my entire body to be able to talk to someone. That's something that's never happened. I've never had issues where I have to pop Advil all day long. And you're like, no, I've never had neck problems before this crash. And here's where a problem can arise. The defense is going to have records from 20 years back, and you gave a throwaway comment to a doctor because maybe you slept on your neck wrong and you had a crick in your neck, but it completely resolved. It's off your radar. You're not thinking about it. But if you say to that defense attorney, I've never had any neck issues at all, you've put yourself in a position where now the defense attorney is going to have an aha moment. Now the defense is going to try to paint you as someone who's hiding facts, or that you do have some issues and you're not being forthright and credible about them. And those are the sorts of things that can chip away at your credibility. A fourth big trap that arises in plaintiff depositions is understanding the difference between things you cannot do, things you will not do, and things you try not to do. So let me give you some context. One of the things that you can recover money for in a personal injury action is your non-economic damages, including your pain and suffering. If you have a bigger case, especially one that involves a permanent injury, you're going to want to be able to show the various ways that this injury has impacted your life. A huge way to show that is to explain the things that you're no longer able to do, or perhaps the things that you no longer do because it's either too painful, it's too difficult, or it just is no longer enjoyable. And those are two very different things that you have to keep in mind. So for instance, let's say that you suffer a bad back injury in a truck crash case and you have to have surgery. Now, let's say that before this crash, you were an avid runner and you would run 4 times a week, 5 miles each time you would go out. But since this crash, you no longer do it. It's one of those things, your back feels fragile. If you try to run, you can feel that compression in your back and it just hurts. And you've tried doing it, but it just hurts. Now, if a defense attorney says, what can you no longer do? And you say, I can no longer run. The reality is, if you can run 10 feet, you can still run. And it sounds like like we're splitting hairs here. So it's important to understand that just because you choose not to do something doesn't mean that you can't necessarily do it. A fifth major trap when the injured party guesses an answer to something. And sometimes we may not know the answer, but we're willing to take a guess because we think we heard at one point that might be the answer. It's really important when giving information in a deposition that we give information that is known instead of information that we believe to be true because we heard it somewhere else. You want to make sure you understand the difference between guessing and knowing before you go in and start answering questions. In conclusion, these are 5 of the biggest traps that I see time and time again arise in depositions of injured plaintiffs. Again, this is information only. These are my observations. This is not legal advice. Every single case is different. If you're someone who has been injured and you are looking for legal advice, feel free to reach out. I've got my number here. I've got contact information below. I'd be happy to talk with you to see if I can point you in the right direction. But thank you for watching. If you haven't yet, please consider subscribing and liking this video, and stay tuned for more. Thanks.